all persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everyone. I see we're already ready for our first case, but I'm going to first introduce the panel to everyone. To my right is Justice James Milkey. To my left is Justice Catherine Hand. My name is Ariane Vuono. As you can see, the first case we're going to be hearing in a hybrid situation, so I want to thank everybody for accommodating that, just so we can still hear the case today. We very much appreciate it. We're going to take a very short recess after this case, and so that the monitor can be taken down, and then we won't be taking another one, so we'll get through the rest of the list as fast as we can afterwards. All right. Briefly, everybody in here knows that there's 15 minutes to present your case. Here we have on two occasions in cases today, we have time that's being split between people, and the clerk knows that, so we're set to go. There is no rebuttal in the appeals court in Massachusetts. So with that said, I'll call the first case, which is number 2022-0997, Department of Children and Families versus Others and Mother and Others. Of course, we all remember this case is impounded, so please do not use any names.
Thank you. Good morning. May it please the court, I am Attorney Diana Spanos, and I'm here representing the appellant father today. My client, the juvenile court judge, terminated the rights to his children, despite the fact that he was parenting a child at home at the time, without issue, with no known police reports or no state intervention action regarding that child. I believe this case, excuse me, I believe this case is really about fundamental fairness or unfairness, as you would, say. Essentially, after an incident involving my client and his stepson, the department removed all three children and placed them in two different homes. Well, originally they were in three different homes, but two are in one home and one in another. But none of those homes used ASL. My client is deaf. He's profoundly deaf. The mother is also deaf, and two of the youngest children are deaf. While the department is charged with the duty to make reasonable efforts to reunify, I don't know how they could have imagined doing something like that, where the children were not learning ASL or using ASL. And at the same time, because of the incident regarding my client and his stepson, the mother had taken out a restraining order at first, where she put all three children, well, it was alleged that she put all three children on the restraining order, excuse me. Mm-hmm. And I don't believe that that ever happened. I think it was just the oldest child who was involved father was involved in a criminal case where the child was the victim. Because of that, my client went months without even seeing any of the kids. He never saw the stepson again. But his own children, he didn't see them until September. The removal was in March. He didn't have his first visit until September. That visit went very, very well. Shortly after that, he and the mother moved to, well, the mother dropped the restraining order and moved to Indiana, where father is originally from. His sister helped them get a house. Mother was pregnant at the time. She gave birth, and as I noted, that when the juvenile court judge terminated his rights, they were positively parenting that child in Indiana. The trial judge made some findings that father did absolutely nothing, basically, and that's incorrect. The father did complete a batterer's intervention. And I will note in my brief, I may have made an error. I don't think it's entirely clear. I said that he completed anger management. After I read the department's brief, I went back and looked, and it looks as though he completed, his therapist was licensed in anger management, but that he was doing the steps for batterer's treatment. And the department acknowledged at trial that they had gotten that certificate. So he completed, if you look at it that way, and truthfully, there is discrepancies in the record, but if you look at it that way, he completed batterer's treatment with a licensed therapist who is licensed in anger management. He also, and again, it's not entirely clear, but his advocate in Indiana, Philip Payne, had told the department that he completed a parenting course, and it was a 2-session parenting course. The worker at trial testified that she got the first certificate, but not the second certificate. Philip Payne did confirm, and it's in the record, that the parents did finish it. He, at one point, said, I don't know if it was done virtually or not, but he finished it. And what my client did not do was write down on his own what his safety plan would be.
Attorney Spanos, could I ask, can you tell me what the timing between your client's completion of the programming that you're describing and the mother's reports of sexual violence by the father against her?
They were completed after that alleged incident. So, I mean, you know, the record isn't entirely clear when that incident happened. Presumably, she said that the child that she's now raising was the result of that.
Right. Was there anything definitive in the record to say that that was the last instance of that kind of violence?
Well, mother denied any violence after that. I guess that's as far, as it can go. And, I mean, again, there's no incident, there's no evidence of police records in Indiana or mother, and the judge did find that there was some state intervention when mother apparently required hospitalization. She had given birth to the youngest baby in November, and father was arrested on an outstanding warrant. He testified he didn't remember the court date. So he was arrested by Massachusetts and brought back to Massachusetts, arrested by Indiana and brought back to Massachusetts, where he stayed in jail for 3 months pending the resolution of that case, to which he pled guilty. And he
And talking about the case involving the stepson.
Yes. Well, and at the same time, the case that had been brought regarding mother's alleged, allegations was dropped. And, I mean, the judge doesn't do any analysis of, mother testified that she made those statements, but it was the same woman who was translating for her with both the police and with the department at the hospital. That was the woman that had filed numerous 51As, which the department unsupported prior to this incident when they had moved to Massachusetts from Colorado. So there's some questionable how truthful those interpretation might have been. Mother felt that the woman's name was Patty, that Patty had wanted to keep her stepson, didn't want the stepson to leave. And in fact, in one of those 51Bs, Patty does tell the department, we would like to keep the stepson. We want mother and father and the 2 children to leave. They wanted them out. But getting back to the reasonable efforts piece, I mean, the department is required to make reasonable efforts, and that includes visitation. And here, the department was relying on a restraining order, which is, even the judge says, is confusing. Yeah, he can't tell, but visitation is probably the most crucial piece. It not only maintains the parental-child bond, but it also it allows the department to see how the parent is doing, and in this case, of course, COVID happened, and COVID really messed everything up. You have 2 deaf parents who were offered 1 hour a month on a video, Zoom visit, with children who were 2 and 3 years old, not learning how to sign. I mean, the older of the 2 younger boys, had gotten hearing aids, and his foster parent made absolutely no effort to get him into any kind of a program. The other little boy, his mother, foster mother, had some class in college where she had learned some basics and was doing some training, but even she suggested that the child was in the READS program, but he wasn't signing. It was not an emphasis. So after the last ADA meeting,
I will tell you that your time is actually up. That
I think it is.
Just so you know, but is there anything you wanted to conclude with?
just in recap, that I really feel that both of these parents did not get the fairness that they deserved. And on that note, I will rely on my brief.
Okay.
Thank you.
Thank you.
Good morning, Your Honors. Daniel Katz, successor appellate counsel for Mother. As my sister remarked, I would like to talk about visitation, and I would implore Your Honors to look at LB versus Chief Justice of the Probate and Family Court Department, 474 Mass 231, 242 in 2016. And there, the SJC said something which I hope all Your Honors will keep in mind as you listen here and as you re-review and make your decision. Visitation, like custody, is at the core of a parent's relationship with a child. Being physically present in a child's life, sharing time and experiences, and providing personal support are among the most intimate aspects of a parent-child relationship. And as my sister said, visitation provides two real important aspects in these types of cases. One, it gives it's the only opportunity that a parent has whose child or children have been removed to parent. And at the same time, as my sister said, and I know I'm repeating it, but it's also for my client, it gives an opportunity to the department to evaluate the relationship there. And what happened here, very unfortunately, is that two, not one, but two social workers did not realize that the department in July of 2020 had actually set forth a policy that we can now move from virtual visits to in-person visits. And it wasn't just a one-off situation. I mean, oftentimes we're up here because we're the appellant and the parent is not always consistent in visitation, and then we're highlighting a visit that went well, and then you might say, well, there was a visit that didn't go well. It's not a situation here where there was just, one or two visits where the department didn't facilitate the visit. There was at least a 6-month period, and it wasn't just one social worker, it was two social workers. So piggybacking on what my sister said in terms of fundamental fairness, not just this theory in the air, but practically speaking in terms of how is a parent supposed to demonstrate, given their right to rebut allegations of unfitness, how is that supposed to happen when the department itself unintentionally or not puts up severe roadblocks? And even during the visits that the parents had, most of them went well with two of the children. There definitely is evidence that the eldest child was often on the phone. But speaking of that child, I would implore Your Honors to look at the fact that although the judge makes a finding that the last visit was a while ago, the social worker never talked to the therapist with the therapist of that child to find out or to inquire why are we getting information that the child doesn't want to see his mom? That information only came from the foster parent who wants to adopt him. So I feel like in terms of fundamental fairness, in terms of, there has to be clear and convincing evidence, right? The evidence has to be full, decisive, and clear. Well, how can that be the case here on this record before your honors, where you have the most important aspect, visitation, and then you have some serious holes in terms of, are you really going to make a termination decision based on the department saying, well, the foster parents said the child doesn't want to see the mother, boom, that's it. Whoa, that seems quite unfair to me, and I hope to yourselves.
Could I just ask a question? The eloquent language you quoted from the SJC case at the beginning of your argument, wasn't that said in the context of visitation post-termination? They're talking about the importance of visitation in that context as opposed to what you're focusing on, which is visitation as a testing ground of parenting ability.
Well, whether that was the specific context or not, Your Honor, I strongly believe that since it is the only experience that can be judged by those who are judging, and the fact that it is taken away, it has to apply to all situations. When you look at a termination case, okay, we'll look at the visits that happen, before, and yes, the parents did decline virtual visits, but geez, during the pandemic, with the ASL issues, it seems quite devastatingly unfair to judge the parents for not wanting the virtual visits given that situation. But I think this quote, and I agree it was eloquent by those judges, I think it has to apply to all these situations, because how else are your honors going to look at a full picture of the case and decide, yes, the evidence is strong. And there was evidence, as my time runs out, that the judge didn't take the fact that despite the relationship issues that mother may have said, the judge never made a finding that there was a rape. And also the fact for 2 years, mother got stable housing and she and this man were raising this child without any evidence of any issues.
Okay,
Thank you.
thank you.
I apologize. I had actually emailed the court, had a conversation with child's counsel. We're splitting our time 10 minutes and 5 minutes. That may have gotten lost in the shuffle with
Okay.
all the other activity yesterday. I do apologize.
That's okay, so it's 10 minutes
Yes.
and 5 minutes. All right. That'll work. Perfect.
Thank you.
so
May
much.
it please the court, Jeremy Bayless for the Department of Children and Families. This is a case about domestic violence. In 2019, this father brutally assaulted a very young child, punched him repeatedly in the face, causing his face to be swollen, his mouth to bleed. His body was covered in bruises. He pled guilty and was incarcerated for assault of that child. That was not the first time that father had struck this child in his care. The family had first sent this child away from Colorado after Child Protective Services had become involved after father had struck the child in the eye. Father claimed that that was accidental. He struck him as turning. The court did not credit that testimony. This was not the last time that there was violence in the household with this father. In March 2019, the mother reported that father had forcible sex with her. At trial, mother testified that father had forcible sex with her. However, she testified that she did not consider that to be domestic violence. She classified it as a misunderstanding.
That domestic violence was not in the presence of the children, correct?
Because the children had been removed from her care because of the earlier domestic violence. What it is probative of what would happen if the children were put back in her care. The fact that after losing the custody of 3 of her children, and after experiencing sexual assault, And as we know from both mother's testimony and from the testimony of father's sister, that mother had to flee the home because of father's temper up to the time of trial, we know that despite participation in services, the parents still had not developed a safe and functional understanding of what is domestic violence, what is violence in the home, and what would be the impact on children who were returned there. Mother's plan for caring for these children, specifically the oldest child who father had abused, was that under no circumstances would father be left to care for him because she didn't want to see the oldest child hurt again. That does not indicate that mother believes that the issue was resolved. That indicates a fear that this assault would happen again. The fact that mother, throughout the life of this case, father, throughout the life of this case.
But it is obviously possible that the father viewed the three children differently.
Certainly.
Given that two were his biological offspring and one was by somebody else. Was there any direct evidence of domestic violence? I don't mean observing domestic violence, but actual violence perpetrated by the father against the two younger children?
There was a little, but not much. There were unsupported reports during that period where the department received a string of unsupported reports. It appears the court may have given more weight to those, despite the fact that they were screened out, but nothing rising to the level of a police response supported after investigation or anything like that. However, that doesn't mitigate the harm that children would experience if they're put back. And if it is a situation where the court were to return the two youngest children, not the oldest one, because there was a clear issue between father and the oldest child that it seems every party acknowledged up and including at trial, those children would still be at risk of being exposed to whatever is happening in this home, which is in Indiana. The department doesn't have eyes on the home the same way they would here. So while it is correct that there were no police responses, there are no Child Protective Services reports from Indiana, given that there was testimony that mom is still having to run away from father and go to her father's sister's home because of father's anger and outbursts, it certainly was not error. It was not an abuse of discretion for the court to find that something there is not safe. And then the court has the testimony from both parents at trial that indicates that they don't have the understanding of violence in the home that is necessary to keep even the younger children safe from being exposed to that. The SJC made it very clear in Vuono, and this court applied it to these cases in Lilith, that it's not just being physically abused that is the harm from violence in the home, that children are supposed to feel safe and secure in their households, and when they witness and are exposed to violence in the home, even if it's not against them, that is a distinctly grievous sort of harm that can affect them well beyond the healing time of bruises or a bleeding mouth or the other harms that we know have happened in this case. The court didn't err in looking at the evidence before it from the testimony of these parents, from the testimony of father's sister, in finding that these parents, despite whatever services they participated in, had not developed an understanding sufficient to remedy their parental deficiencies. And then when we look from that to the reasonable efforts argument, the SJC was also emphatically clear in Walt, which was extended into Rashida, that under no circumstances should a child be left in an unsafe environment. So while the court found the department's efforts through the COVID pandemic, where I think everyone can agree nothing worked well or the way it was supposed to, but visitation here did not carry out the way that it should have or the best way that it could. But the department's efforts in trying to deal with an unprecedented pandemic through proposing virtual visitation when it was unsafe to be in person, and the unfortunate oversight by the social workers when in-person visitation renewed, the court did not err in that. But even if it had, even if the department did fail to make reasonable efforts, no child should be left in an unsafe environment. And the parents' history of violence and the parents' testimony at trial indicating that they still didn't understand why that was bad. They still attributed the assault on the oldest child to a sub-10-year-old child. It was his fault for having an attitude or talking back or otherwise being difficult that he was assaulted. That forcible sexual assault on the mother was not domestic violence, it was a misunderstanding. The father says domestic violence can't involve a child because it's something that only happens between adults. The violence in the home is going to continue. These children are at significant risk of being exposed to it, and after the lengthy period that the parents did have to improve their parenting, they simply didn't do so. So the children would be at risk put in their care. And as such, if there are no further questions, I'd simply end by saying that the judgment should be affirmed, and I will rest on my brief for the rest.
Thank you very much.
Thank you.
Good morning. Can you hear me?
Yes.
Yes.
Okay, great. Thank you very much for allowing me to participate virtually. I assume that none of you want your holidays ruined. So, Your Honors, I represent the children in this case, and in my 5 minutes today, I think it's important to talk about the visitation. The parents' attorneys today have talked about visitation being the most crucial piece and at the core of the relationship. And that is very much true in this case. But during the time that, I'm sorry, I've lost everyone. Hold on. I'm sorry. I'm sorry about that. I can't see Your Honors. I can only see myself.
Oh, okay. Well, we can still see and hear you.
Okay, good. Thank you. During the time that the parents did have with their children, and while the visitation, it was virtual, and there are definitely difficulties and limitations with virtual visitation, the parents did not avail themselves of the opportunity to build relationships with their children. Now, I do agree that virtual visitation with very small children is exceptionally difficult. However, the parents left their children and moved to an entirely different state. So even if in-person visitation was available, they wouldn't have been able to take advantage of this. There was evidence in the record that the parents did not participate in virtual visitation for several reasons, not just because of the difficulty, but because they were overwhelmed with the services they were doing, or car troubles, or other issues such as that.
Attorney O'Brien, this is Catherine Hand. Is it not true, though, that the parents did make at least one visit from Indiana up to Massachusetts as in an effort to meet with the children?
Your Honor, there was one visit that they made, and then there was another situation where the parents had to come back to Massachusetts to attend one of father's court hearings, and mother had called and asked for a visit very last minute, I think the day before, and the department was not able to facilitate that visit. But if you look at the visits, particularly between the older child, who's not father's biological child, and mother, he spent most of his time on his phone or in a corner, and the engagement was not there. In fact, mother said at one point she did not want to visit with that child because it was too painful or too difficult. I think in this situation, yes, DCF could have done better with the visits. But the parents didn't take advantage of the time that they had with their children.
Well, Attorney O'Brien, let me ask this, and I'm sorry to interrupt you if I did. Catherine Hand again. The parents make an argument that part of the problem with their extended remote visits or virtual visits only was that they had difficulty communicating with children using ASL because they either weren't being instructed on it or weren't proficient at it, and that was made more difficult by the fact that they could only have visits virtually. What do we do with that?
Your Honors, I think that this goes back to the reasonable efforts argument where DCF made 3 separate appointments for ADA accommodation services, and the parents attended one of the meetings and said that there was nothing that the department could avail themselves or could help with that would make things better. You have children who, for whatever reason, don't want to wear hearing aids or aren't participating in this. I think that the foster mother who did have some experience with ASL and was trying to educate herself better, tried to get the child to do ASL, but at the end of the day, the IEPs on the other children suggested that it wasn't necessary.
Thank you.
I don't know, Attorney, if you've kept your own timer, but your 5 minutes is actually now up, so your time is up. Is there anything you wanted to say in conclusion?
No, thank you, Your Honors.
Okay, all right, thank you very much. All right, well, we'll take the case under advisement. We always recognize these cases are very difficult, and they bring up a lot of emotions, and so we'll take a very, very close look at everything that's been presented to us today. Thank you. Court's going to take a very brief recess, and so the monitor can be taken down, and then we'll come back and hear the next case.